All right, everybody, welcome to the Creative Finance Collective. This is our opportunity to get together and talk about all things creative finance. We may have others join us. We'll see. We'll be on here for either an hour or as long as we're getting questions. So if we don't get any questions, we'll move on. But if we do have creative finance questions, we'll get to those, and that's what we're here for. So if you have a question, creative finance related topic, any question works. We're here to answer it. So post those, um, and we'll get started. All right. So we already we have a question, Sean, and I'm going to read this and see what you think. So can can I wholesale a contract to purchase a property from a seller that bought the property subject to? Can I wholesale a contract? So I think this is a new buyer who's entered into contract to buy a property from a seller who themselves bought the property subject to. So they own the property subject to the existing loans. I think that's what this is saying.
Yeah. So can you? Yes. Is it wise? Maybe not. So basically, as long as in most states, Arizona for sure, if a contract does not have a provision in it prohibiting its assignment, and the other party will not be, prejudiced by the assignment of the contract, then the assignment can be assigned, basically. So if it's silent, it can be generally assigned. Now, if it's silent, that's not to say that the seller could potentially say, well, that's not who I contracted with. I'm not going to sign the closing documents, et cetera. And then you have to go to court and fight over it, right? Now, if the contract has language saying that it's fully assignable, then the buyer who's acquiring the property from a seller subject to could then assign it. Now, whether or not it's wise to do that, there's a lot of complications associated with assigning a subject to contract. You need to make sure that the buyer fully appreciates what's going on. That they understand. You need to make sure that, Dodd-Frank and other statutes are being complied with, et cetera. So there is, more to it than simply just assigning it. But legally, can you? Yes. Whether you would want to is a whole different story.
Yeah. Hey, Scott, I see you just joined us. How you doing?
Well, I joined you a long time ago. I just didn't push the right button to actually join you.
Oh, well.
I thought you guys are poking around a bit, and it winds up being me.
Well, we're glad to have you. So we got a question, and we'll get your take on it. Let me read it to you. Sean was just giving his take. It says, can I wholesale a contract to purchase a property from a seller that bought the property subject to? So this seller previously themselves bought the property subject to, now they're selling it, and the person buying it on that contract wants to know if they can assign that or wholesale it.
And so they haven't closed on it yet. They're just under contract, right?
Yeah, or or theoretically they're thinking about the opportunity to do that. But yeah, it hasn't closed. It wants to know if that can be done. And
I didn't get a chance to hear all of Sean's comments, which I'm sure were awesome as usual.
As usual.
I know.
I think that the sum of it was you legally can do it, but there's a lot of things to watch out for.
Well, here in Texas, the first thing is you have to have a certain clause in your contract or in your disclosures or somewhere that specifically stipulates that you're only assigning and selling the contract, not the property. That's number one. Other states may have similar things or even have prohibitions against that in some format. So I'm only going to speak to Texas at least. No, my biggest thing is at least here in Texas, everybody thinks every contract is assignable. Well, I think that's true, but it doesn't mean that the seller has to accept an assignment unless they have specifically acknowledged acceptance of that. And for years in disclosures that I've utilized, I have a clause in them all where the seller is allowing the buyer to assign the contract and then to look to the new assignee as the actual buyer of the property.
Mm-hmm.
And of course, people go, well, why do you do that? We don't need to do that. Sellers just want their money. I go, well, you're right. Sellers do just want their money until they sometimes see how much money you're making. And all of a sudden they want part of your money too. Imagine people are greedy, right? Now, I know that happens mostly in the commercial world. I go back to my commercial days back in the early, late 1980s, I guess. And it was dog eat dog. And, if these developers or builders, if they saw a broker making money, they would cut commissions if they wanted the deal to close, or they would threaten us to walk away. And things like this, where they see an assignment, a contract, they would say, well, we're not closing with the assignee. We're only going to close with the person we contracted with unless you do X, Y, and Z. So my first comment to all these things is if you're going to assign a contract, you should have a proper assignment clause in your contract, number one.
Yeah.
Make sure that you have the things that your particular state requires in that contract as well. And I'd even have the seller initial those things just as a CYA mechanism. Mm-hmm. And I'll make a comment. When I say CYA, we lawyers know what CYA means.
Yep.
I keep asking a lot of people when I'm talking about that, they all kind of look at me funny going, what are you talking about? And it's like, come on, are you serious? It's like, no, cover your rear end, right?
Yeah, I didn't think that was an exclusively a legal term.
I didn't either, but I asked that question and it's just like, no, deers in a headlight. So I think the contracts are fully assignable. It's just being smart, having proper clauses in there. And then if it's a subject to transaction,
yeah,
I want to make sure that seller knows exactly what I'm doing. Number one, I want them to sign off on the transaction. Number two, whoever the assignee is, at least when I draft disclosures between a seller and a buyer, I'm including in those an automatic power of attorney for Texas, as well as an authorization form. Well, if you're assigning that contract and those disclosures, your back-end buyer now doesn't have a POA or disclosures or the information that they need to properly navigate the transaction. And that is where so many problems arise out of. So now you've got to go back, redraft a new power of attorney, and you assign authorization form between seller and the assignee. I want to make sure that that assignee executes, in some format, either by initialing all the pages or something, the contract and disclosures, to ensure that they've seen everything there from that perspective. And here in Texas, we have this underlying lien disclosure notice and insurance disclosure notice. It says every seller must provide a buyer the underlying lien disclosure notice in Spanish and English, and or any other language that the transaction is negotiated in, along with this insurance disclosure notice. And it doesn't say initial it, it says executes it. So now we're having to re-prepare all new underlying lien and insurance disclosure notices for the back-end buyer. Now, that's only true for Texas, not for other states.
Sure.
But you want to make sure that all those little things are handled, because when you go to close a sub-to deal, I want to make sure, A, that our seller is always protected. They know who their buyer is and things of that nature. And if they wish to get financial information from that back-end buyer, they know who to go ask for it, from prior to closing. And so often what I see is these wholesalers, they're just looking to flip that contract really quick. They don't care about any of the issues I just described, not in Texas or anywhere else from what I see. And all they're trying to do is make the fast buck again, which is why they do the wholesaling, it seems like.
Sure.
And it's just getting them to think through the deal and do it right. And I see the same thing with these transactional coordinators that are out there, and their thought process, unfortunately, stops at the end of their nose. You know, they think that a simple assignment is all they got to do. They're not thinking through the things that we lawyers think through. And there is a handful of really good investors out there who really do want to absorb, you know, all these things. They do try to do it right. It's just that I think that's a very limited few, unfortunately.
Yeah. Good stuff. If you're just now joining us, this is the Creative Finance Collective. We'll be on for an hour or until we stop getting questions. So if you have creative finance questions, it's important to post them in the chat and we'll get to them. We have another question. It's not creative finance, but it is a seller finance question. As a seller in a seller carry transaction, are there risks to me servicing my own loan? So this sounds to me like how can I save money type question without and knowing how much risk that I might incur. But what are there risks to servicing your own loan? What do you guys think?
Well, for me, I mean, we service all of our own loans that we're a party to or hold an interest in some format. I just don't trust the loan servicers because the entire investment community believes that a loan servicer is a gift from God in this industry, and they're going to take care of every issue and every problem on your loan along the way. They're going to get out there and they're going to, you know, collect your money quickly and timely. They're going to take care of all the issues, all the little problems. And that's about as far from the truth as it comes, unfortunately. And if I'm servicing if it's a wraparound mortgage, I'm not about to let the buyer and sellers service their own transaction unless the seller is an extremely sophisticated, you know, investor and has the financial ability to handle situations. And the buyer and seller need to agree that, you know, there won't be a loan servicer involved. But 99.9% of the time, there is going to be a loan servicer, which is, of course, our fraud preventer out there.
Mm-hmm.
And gosh, guys, I go back to through the 1990s. I bet you I white knighted 15, 20 deals from my banks where, you know, owner finance buyers were paying the investor who wasn't paying the bank. And of course, the bank's getting ready to foreclose. They give a call to me, both as the investor and as the lawyer, to go and fix the problem in order to help that back end buyer out of the situation they were in, which we were able to do in most cases. But you know, if you've got a really good, sophisticated investor, I'll let them service their own loans. If our firm is going to close it, what somebody else does, I don't care. Otherwise, I want to use that loan servicer along the way. So I don't see any negative issue so long as you are a owner of that mortgage. I think you have the complete right to service your loan.
Yeah, don't disagree with that. Have the right to do it. So what about on a straight, just the simplest type of seller carry transaction that there is? So I, you know, sold the property, but it's bought and paid for, and I'm just going to carry the note as the seller. I mean, there's got to be some risk to not using it. I mean, the risk, right, is that you don't keep proper records. And then you need to go foreclose later on?
I mean, that's one. Making sure you have your original note, those kind of things. I just had a call today where a lender did a wrap loan, had lost his original notes, and he's foreclosing, and this law firm had asked him for a copy for the original note. And I said, just tell your lawyer you don't have it, you lost it. And if you need to do a lost note affidavit, go do a lost note affidavit. It's easy to do. It doesn't invalidate the transaction. People lose documents all the time. And of course, in the case I'm speaking of, there was even a bankruptcy before that, where the owner occupant of the property being foreclosed on had affirmed the mortgage in the transaction along the way. And you kind of go, okay, you got a federal court that they had filed all their records in. You're going, do you really need more evidence than that? But they don't understand how to do those little details. But I think it's also in talking about servicing the transaction, we're doing this right now, is your escrow and keeping up with it properly.
Yeah.
Now, these loan servicing companies, I'm not going to say they're going to do a very good job. Here in Texas, in the last 2 years, they have skyrocketed our property taxes. I mean, I had a tract of land, to give you guys an instance. I had one tract, these were next door to each other, 1/2 acre and 1/4 acre. In 2023, they were taxed at 40 and 80. In 2024, they jacked them both up 229%. And you're going, do you think a loan servicer is, one, going to fight that? No, they're not going to go down and protest taxes for you. You know, what are they going to do? And how are they going to adjust that for your borrower along the way? In the last 2 years, we had to go in because our borrowers' taxes have gone up so much. By the time we got notices in Texas, it was already late August when we got them. Not March, but I mean August. So, you know, 2/3 of the year is gone. And how do you ask your buyer to pay an extra $2,000 for property tax increases, you know, in that short of a time frame? You can't do it. So we had to spread that out over a period of time. And a loan servicer can't do that. The note holder has to step in and handle that appropriately, both in paying taxes and taking care of things, because most of these buyers can't afford to pay the increase in taxes, even though it's their responsibility to track it.
Mm-hmm.
So, you know, there's a pro and con on both sides. It's easier to let a loan servicer handle things for you, but, you know, I keep telling investors all the time, guys, it is your money, you know, and who is going to collect it the best, you or some loan servicer? But I think the lazy factor kicks in.
Yeah.
I think one of the biggest risks with trying to service your own loans is in the probate context or the death context. So the main principle of the entity that is the lender, or if it's an individual lender and they die and their records are not the cleanest, or their records reflect, you know, defaults and things like that, but they never acted upon the defaults. And now all of a sudden you have an estate that's stepping in, that's taking this over. All of a sudden it becomes their word against the borrowers, and you don't have the deceased person to even explain anything, right? So the borrower could come out of the woodwork and claim, oh, I did this, I did that, and, you know, try to come up with proof or establish, you know, principal payments or that they were current or whatever else. And it's hard to dispute it at that point because the person collecting everything is no longer with us. And so to me, that's a huge risk, is what does that mean for your estate? How are they going to be able to track everything, to figure everything out, get access to your computer where you're keeping all the ledgers? You know, those types of things. It's a major problem. And then, you know, collecting payment in the interim between getting somebody appointed, getting access to the computer, getting, you know, the information on the loan. To me, that is the biggest risk, because we all know it would take a lot of work for somebody to properly set this up so that whoever is taking over for them, it's just seamless, right? And nobody, I mean, maybe a small percentage of people are that meticulous and are gonna set it up, but for the most part, they're not. Versus if you have a servicer in place, the estate, you know, and the estate attorney just calls up the servicer and says, hey, so-and-so died. What's the status of the note? Can you give me a breakdown and let me know what payments have been made and where we stand? And it's as easy as that, versus the other scenario. It's difficult. And I've seen it. In fact, I've had clients who have tried to sell properties where notes were really old, and my clients either inherited the property or, you know, they bought it and nobody picked up on the note, or it closed or whatever. In any event, where we've had to go back to estates or to heirs after 20 years or so and say, hey, we need you to release your deed of trust against the property. And then they've come back and said, well, you owe us, this money. And we're like, we don't owe you anything. And now it's a dispute. Nobody has the records. And so we went and said, hey, look, you claim you're owed the money. Well, I need to see the records that were kept showing this. And of course they couldn't produce any. And so they eventually just had to release their lien. But what do you do? What do you do when somebody dies? How do you produce it? How do you prove it? So if you have a servicer, none of those issues even come up.
Yep. And I agree with that too. Not only is it a probate issue, Sean, that can arise, and I've seen that happen many times where, the wife has no clue what the husband is doing, doesn't know where the records are, or the kids don't know any of that either. And it's just, they're stuck having to recreate the thing through some format, or go back to that borrower to get copies of canceled checks or something like that along the way. Or how do you create an amortization schedule if they didn't keep good records?
Right.
If you're in a corporate environment where you have several people touching the same thing, that's one thing.
Right.
It's kind of like my offices. If you're an individual and that's it, and it's just you, where's your backup? How do you create things? Where's a third party that might know something to be able to put it back together for you? Right. But also another thing that pops in mind real quick is your payoffs and your pay histories. If your borrower's trying to refinance a property, they need to see a 12 or 24 month pay history. Who are they? Or maybe it's a note buyer. Maybe you are selling that note, and the note buyer wants to see that pay history. Where do they get more credibility from? From the note holder who's trying to profit from it, or from the servicer?
Right.
And so there's a double-edged sword out there occasionally in how you look at things. There's a pro and con to everything you do, and it's just really based upon what works best for the note holder, and what's best to their advantage, and what's their goal, both short and long term. But again, those goals change, with time. That's another thing the investor world doesn't think about is, today they may not be planning on signing that note. We're just going to hold it for a long-term investment for the next 30 years. Great. But what's going to happen in 3 years from now, or 5 years from now, or, you decide to move to Costa Rica and liquidate, or yada, yada, yada. So it's always nice to have a third party backup of some type.
Yeah. Well, I always understood that notes that were professionally serviced were more marketable than those that are serviced individually.
Well, it certainly doesn't hurt. How about that? Would be my answer. The more credibility you can give to a financial document, the better.
Right.
So I think they just need to understand that and make sure that they've done the right thing along the way, and roll from there. But goodness gracious, so often they just don't do that, though.
All right, good stuff. If you're just now joining us, this is the Creative Finance Collective. We're taking questions. We'll be on for the rest of the hour until we stop getting questions. So it's important for you to post your questions. We do have another question. I think this was prompted by our death discussion, but it's a more general question, which is, what happens if I buy property? So I'm the buyer. I buy the property subject to, and the seller dies after the closing. What next? Does it even matter?
Assuming you have access to the loan information electronically, it should be business as usual, and then the note just gets assigned to the seller's heirs, and they can enforce it should you not make those payments.
Yeah, I don't think there's if the seller dies, so what? Just keep going forward. Just make sure that if they do die afterwards, I keep telling investors, you don't have to tell the mortgage company someone died. There's no obligation to do that. Just keep making the payments and move on. Unfortunately, there are many, heirs who think they have to call the mortgage company and tell them these things. And that puts the brakes on everything, because now you've got to get letters testamentary, heirship affidavits, something executed and delivered to the mortgage company. Then you've got to get a power of attorney from that particular heir or executor so you can communicate with the mortgage company yourself along the way in order to start handling things, and go back online and make other online changes, because they'll shut things down as soon as they find out someone's passed away without some type of probate evidence that's out there. And, I don't know. Yes, I think here in Texas, for instance, you need to contact the county tax assessor's office, because if that property owner had exemptions on the property, over 70, disabled, maybe they're a vet, whatever it might be, that when they pass away, those exemptions get removed immediately. And of course, 2, 3, 4 years later, the property gets sold to a third party. Will the county roll the taxes back? And now you got to pay all those back taxes that no one expected or anticipated from. So I understand contacting the county, but I don't know of a regulation that says you've got to contact the mortgage company. And it's when you contact the mortgage company, all of a sudden, all the brakes get put on, and then it just exacerbates things. So sometimes less is better in those scenarios.
Let me throw a little wrinkle in here. Same question, but the seller dies before the closing. In the middle of things, but prior to the actual closings. So they've signed the purchase contract. We just haven't closed. Oh, I hear a sigh.
Well, since Sean's already geared up for it, have at it, mister.
Well, at least in Arizona, you could enforce the contract against the estate. And so the estate would be the lender on the performance note and deed of trust, but you might have to go into court to convince the estate that that's what they have to do. So it's enforceable. It just creates a little bit of a wrench into the system there, potentially.
Yeah. We would normally, in that scenario, we would want the estate of the seller, because there's no one, maybe a contract's been executed, but closing docs haven't been executed, and that hasn't happened. Right. How are you going to close the deal? You got to get someone who has authority to sell it. So now you're either in probate court, muniments of title, heirship affidavits, something. So again, the brakes get put on. You got to fix and solve that problem along the way.
Yeah,
you got to really want that property if you're the buyer at that point.
Well, yes and no. I mean, sometimes it's fairly easy to do, and sometimes it ain't so easy to do, right?
Yeah.
So I think all those things pop up along the way, unfortunately, and what we have to contend with.
Right. Interesting. Well, that good stuff. That's all the questions we have so far. We'll maybe BS here for a little bit longer. If you have a question, make sure to post it in the chat. We're here as long as we're getting questions. Scott, we haven't seen you since Thanksgiving. Did you have a nice Thanksgiving?
Wasn't that just last week?
That was just Thursday. Yeah.
Oh, sorry. Yeah, actually, day to day, we had like 12 foreclosures on the list today, and all but 2 got cleared one way or the other.
Wow.
That was kind of saved me running all around town in the countryside. So that was good. But Thanksgiving was good. Weather was actually pretty good here in Texas. So it was nice. And all of my family is pretty much local. So that's nice. We either do it at my house, my niece's house, that's actually right next door to me, or my sister that's about a whole 2 miles away. So it's nice and convenient. You're not traveling, across town or across country. I've never had to deal with airports on Thanksgiving before. It's been pretty nice.
Oh yeah, I wouldn't want to do that.
And I can see them doing this kind of thing. How about you guys? Do y'all actually eat turkey out there in Arizona?
Yeah, we do.
Okay.
We do. One time a year at least we do. So,
are you not a turkey fan?
I like turkey fine.
Okay.
I'm okay with having it more than once a year. It just doesn't seem to ever come up. It just seems like every time you're given the option, something else sounds a little bit better than turkey.
No, I don't know about that.
Well, I don't know. If you went to dinner and somebody offered you a brisket or turkey, which one are you taking?
Depends.
Depends on if it's Thanksgiving or not.
It depends on the brisket,
Well,
but I like them both. And grant you, I will if I'm at a barbecue joint and it's brisket versus turkey, brisket's going to win.
okay.
Okay, I got that part.
How about steak versus turkey?
Oh, come on. So, but actually, so here's a question. See, I actually, although I like turkey as a traditionalist, so when you are an Aggie, you are a traditionalist for the most part. Because A&M is just full of traditions, okay? And so, yeah, I like turkey and the usual things on Thanksgiving, like it on Christmas. Of course, in my family, they want to do funky things sometimes. And just, well, let's do 12 salads. And you kind of go, what? But are you more of a fan of turkey on Turkey Day or the next day, leftovers?
I'm more of a fan on Turkey Day.
Because I like leftovers.
Yeah, lots of folks in my family do. I like it. I like it fresh day of, but I don't know.
So I like them both.
Well, good. Well, guys, that's all our questions. You're very generous with your time being on here, answering those. We had good questions, good discussion. With that, we'll go ahead and call it, and we'll see you next week if you're available.
Well, that is great timing, guys. I have to go get a birthday card and pick up a birthday cake and go over to a winery for my wife's birthday tonight.
Wow, that sounds fun.
That sounds cool.
Yeah, nothing fancy, just a small family gathering.
They have wineries there in Texas.
Can you believe that?
I know.
We drink. Yeah, we don't drink around here. We guzzle. Unfortunately. Well, guys, we'll look forward to seeing you all soon next week, I guess, right?
Yeah, sounds good.
Yeah.
Have a good one.